Good morning, everyone. Thank you for joining this meeting of the Trade and Business Commission. My name is Alan Winters. I'm chairing the first half of this morning's session, which is dealing with digital trade and particularly data issues related to it. I'm not going to say anything more other than I think everyone who's bothered to sign in knows that digital trade is a hot topic and a big topic. We're planning to arrange mainly sort of big picture questions in the first half and rather more specific questions on data adequacy in the second half, which Alison Williams will be chairing. For the first part, I've got three expert witnesses, and I'm going to turn to them to introduce themselves to you for a minute before we start with questions. So let me first start with Emily Jones.
Good morning, everyone. It's a pleasure to be with you all. I'm Emily Jones. I'm an Associate Professor of Public Policy at the Blavatnik School of Government in Oxford.
Thank you. And then next, Javier Ruiz.
Hello, hi. I'm Javier Ruiz. I'm the former policy director of the Open Rights Group in the UK, and I'm currently working as a consultant on digital policy and also as an advisor to the Digital Trade Alliance, which is a global coalition of civil society organizations coordinated by Public Citizen in the US.
Thank you very much. And finally, for this half, Sabina.
Hi everyone, great to be here. I'm Sabina Ciofu. I'm the head of EU and trade policy at techUK. We represent around 850 companies operating in the digital economy in the UK.
Thank you very much indeed. I think people know the routine. We've got a series of questions, and we'll sort of direct them perhaps to individual people, but other witnesses who want to join in, please try and catch my eye. We have tight time constraints, which Flo is going to enforce with rigor. So the first question is just, in a sense, a scene setting, but what exactly do we mean by digital trade? Emily, do you want to start off with that?
Sure, thank you. And it's a simple question. The answer is never that simple. I think it's quite a contested issue. So the OECD gives us the definition of, I think, digitally ordered or digitally delivered goods and services. I like to have a little bit broader than that, because I think actually the digital economy underpins even very traditional services. Sort of sectors. So if you think about, I don't know, horticultural products moving from Spain to the UK in a lorry, right, going to your supermarket where you pick them up, this is sort of old school, if you like, traditional trading goods, but actually even the lorries, they've got sensors built into them, the supply chain's optimized with data. So for that to function effectively, it's the digital economy underpins it, data flows are important. So I would like a slightly broader definition of digitally enabled trade.
Okay, thank you. Javier?
Hi. Yes, so I think for me, digital trade is actually almost like three different things. At one level is more or less what Emily was mentioning before, which is what would be the cross-border component of the digital economy or the digitalized economy, or anything to do with digital. And in that sense, it could be very, very broad, as we were saying, agriculture to anything. But then from the point of view of trade policy, for many years, there was this idea of e-commerce as the main thing that had to be promoted, and that could mean things like digital signatures, being able to do paperwork across borders, enabling a lot of the online ordering, that Emily was mentioning before. But nowadays, for example, the Law Commission is having a consultation on the paperless trading, including bills of lading. For example, if you buy a whole transatlantic full of oil, you are probably going to do digital trade because you're going to sign some digital paper to take ownership of your billions, potentially, of money. So that is an area. And then in the past few years, there's a third idea of digital trade, which is being started mainly from the US and technology companies, which is around restrictions as perceived on the activities of global digital companies, or like Google, Facebook, or others, that are less known. And in this sense, digital trade becomes a shorthand for the regulation of the global digital economy, and not just the digital economy, but the internet as a whole. And that is where things start getting a bit more problematic, I think, for consumer groups.
Okay, thank you very much. Sabina.
Thanks. Not a lot to add. I would very much agree with what Emily said in the beginning. I think, the kind of agreed definition so far is a bit narrow, considering just how pervasive digital is in all sectors of the economy. I would also maybe just add that, what underpins digital trade is the movement of data. So when we talk about digital trade chapters, digital trade agreements, we often talk about data flows and how that's moving across borders. And probably important to note here that it's not only a kind of a means of production, but it's something that can be traded in itself. And if you look at like core new technologies, for instance, they become service supply models. So if you think of cloud computing, Internet of Things, things like additive manufacturing. So I think it's just important to kind of add to this conversation that the core of every digital trade agreement or digital trade chapter will always be around data flows and how data moves across border. And that we are seeing quite a lot of restrictions coming to that data flows from some of our trading partners and some of the kind of broader developed economies. So it's an interesting time to be talking digital trade and data for sure. But yeah, just to add that point.
Thank you. Could I ask a brief pointy-headed supplementary? The internet companies collect a lot of data, essentially for free. The data is worth something. Would you seek to make the value of that data part of a calculation about the value of digital trade? And that's open to anyone who thinks they'd like to answer.
I can try to do this. So it's very difficult to quantify. I'm sure Emily would probably be best placed here to add some substance to this, but it's very difficult to quantify the value of data flows themselves. There have been some attempts as far back as 2014. So, of how much, something like, I think it was 2.8 trillion, I might get that number wrong, added value to the global economy. But it's difficult generally to quantify the value of data flows themselves. There are some experiments, and I'm sure we'll touch upon it later on trying to quantify the value of digital trade. But again, experiments because they encompass part of the definition that Emily was talking about in the beginning, as opposed to everything that you could cover with digitally enabled trade. So I think it's just a tricky one to put a number on, although it's definitely something that I think everyone is trying to do. So.
Emily, Javier, anything to add?
Yes, sure. Thank you very much. Oh. Okay,
Emily first, and then Javier.
Thanks, Alan. So I think I think we've got to think about, in terms of the quantifying data, there's the economic value of data, but I think this is where it gets into contentious issues, because there's also the sort of the privacy and other sort of values that we put on that data that are harder to quantify. So I think fully agree with Sabina in terms of the challenges of quantifying the economic value of it, but I think also then we need to bring in the sort of the other values that are linked to data. And it's for citizens, the privacy angle is obviously really, really important. And that brings me to a broader point, which I think, just to pick up something that Javier said, when we're thinking about assessing the impact and I guess the magnitude of digital trade and digital trade flows and what the provisions that we see in digital trade agreements increasingly is to really think about these wider public policy issues. And actually in trade agreements, we're seeing a lot of provisions on data flows, which Sabina has spoken to very eloquently. We're also seeing many other provisions on wider aspects of the digital economy. So I think that is something that I think we all need to be aware of. There's a sort of digital trade narrowly defined as data flows. And then there's a whole lot of bigger and wider issues that I hope we'll get a chance to elaborate on a little bit around how we regulate the global digital economy. And that's everything from sort of competition policy to privacy. And the regulation of new technologies like AI, which again, there are provisions in trade agreements that pertain to that. So we can go pretty wide, I think, in this discussion this morning.
Yep, indeed. Javier, do you want to add anything on that?
Yeah, I mean, just so I think what Sabina was referring to, I think, is the problems with measuring the value of data. I mean, there are several problems. One is measuring the value of data flows, and I think that there the attempts have been very crude, basically measuring the capacity of internet cables, undersea internet cables, and extrapolating from there. And in that extrapolation, I mean, the UK comes quite high because the UK is a very connected country for cables, but it's very unclear how much of that is actually the value of data as such. And also, as Emily was saying, there are not just the social value, but many non-monetary transactions. Like, for example, every time that you contribute to, for example, a review on the internet, that is quite hard to quantify. It's not in GDP or it's not anywhere. So I think that is it's quite hard. But then intrinsically, the one fundamental problem is that data has no value until it's used. I mean, it's only the idea of the immanent value of data is just something that no one has been able to really put their fingers in. And I think that the problem is that until you use it, you don't know how valuable it's going to be, until you combine it with other data, until you have the analytical capacity to really make use of it, you don't really know what is the value. So the question of the value of data is quite difficult. And I think that the analogies that we've seen with oil are quite, have misguided quite a lot of the analysis, because the idea is that oil is an inert resource that will be refined, but it's got intrinsic value. While data is something a lot more complicated, it really depends on on how you're going to use it.
Yeah. Okay, thank you very much indeed. I'm going to pass on now to Liz Saville-Roberts, MP, to ask the next question. So, Liz.
Thank you very much, Chair. I appreciate that we've touched upon the economic value of data per se, and Javier, you touched also upon the fact that the UK is highly connected. Could you, Sabina and Javier, could you give a sense of the value to the UK specifically of digital trade, and the sense of the proportion of this in relation to other countries, possibly those with which we're going to be seeking trade agreements?
I'm happy to start on this. Javier wants to jump in. So yeah, thanks a lot. It's a very good question, and it's something we always struggle with, as we've already kind of alluded in the first round of answers. Putting numbers and values on digital trade flows. So I think as an e-commerce market, so as a pure business to consumer market, the UK is the third largest in the world. So I think there is a number there, something like $266 billion. So that means that we are only after China and the US. So third largest B2C market in the world. Now, when you move away from e-commerce, which is a lot easier to quantify, we've had some experimental statistics done by the Office for National Statistics. So for the first time, they kind of looked into trading services that were delivered digitally. And they put some numbers for 2018 showing that, the UK exported something almost close to 200 billion pounds digitally delivered services, and that's about 70%, almost 70% of UK service exports. So it's huge for the UK economy. It's really big, and we've imported something like 100 billion, about half of UK services imports digitally. So that's why, and we've kind of seen this strategy from the government as well, and this focus on digital trade. It's really important that we kind of focus on that, because I think generally, and I'm sure as you know, we talk a lot about ships and, trading goods when we talk about trade, but for the UK economy and for the large chunk of services of the UK economy, I think this conversation is very important. And these numbers that I just gave from the ONS, they don't capture all of UK's digital trade. So because it's really difficult, as Emily alluded to earlier as well, and to quantify the digital's role in enabling other non-digital trade. So it's still a difficult one to put a number on, but it definitely shows, I think, this ONS statistics show how big it is for the UK economy.
Thank you very much. And Javier?
Yeah, I think that basically following up or to complement what Sabina has said, I think something to say on e-commerce. I think that mean, rather than talking about figures, I think that would be interesting for the Commission to think of what are the issues and how to, some of the things that we need to look at. For example, one thing is like the UK is definitely a great market for e-commerce. The British people are great consumers of e-commerce. It's not clear that the UK would be a great exporter of e-commerce in a digital trade sense. And there are many issues that could play there, that have to do with like the local conditions here. So that's something where more work is needed. There is also, going back to what Emily was mentioning before, the difference between the digital economy and the broader digitalized economy. That is where a lot of the work is required, as was mentioned before, from industry and many other areas. There is work at the OECD to try to measure what they call the digital intensity of various sectors, which means like the level of ICT investment, robotics, and other things. And they've created, they are creating a method there. It still doesn't feel that it totally captures, like the broader effects, because it feels quite focused on high tech, things like robotics, which for the UK, given the low manufacturing base, may not be that relevant. But there is an attempt. I mean, that is the line of direction, and there will be. I think that obviously the people you will need to talk to are the ONS, because they do have an innovation program to try to measure this through surveys and other areas. But I think that the thing that is also quite important is that when many people talk about the new digital economy, and particularly when it comes to internet regulation, the main thing that is being measured in terms of the cost of data flows, of barriers to data flows, is the cost for local companies in a country to do digital using foreign cloud providers vis-a-vis having to use local ICT. And that is quite a lot of the analytics on the cost, the economic cost of barriers to digital trade. And those costs are actually quite narrow. They're looking at the kind of the cost to a firm, but they're not looking at the wider innovation for the country, on the other end. So if you look at countries like India, who are promoting some level of data localization, what they are doing is trying to develop their own native ICT industries. So it's a bit, I mean, I'm not saying that is the right way, but what I'm saying is that you need to look broader than the cost to one firm of having to pay more money for a service, and looking at the wider impacts on the economy of having a stronger native economy. So that is another quite important aspect. Then you have complications around the platforms. For example, if you buy, if I rent an apartment in the UK in Airbnb, is all that transaction a digital trade transaction, or is only the money that goes to the US? Because a lot of the money will go to the owner of the bed and breakfast in the UK. So there are some complications in terms of how to split, what is the digital trade part of the digital economy. Then you also have complications with intra-firm transactions on data, which are very hard to measure. No one is measuring. So there are all these other areas, that, I mean, I cannot give the value, I don't think anyone, but I'm saying that there are many things that you need to consider, as you want to quantify the value of digital trade.
Thank you very much, Javier. That's really interesting that you said that the UK is a great market for consumers, and then you go into some of the details of the issues that maybe that haven't been considered when it comes to, from the business point of view and from the trading point of view. Are there any that are specifically to the UK that you think we should be aware of?
Well, I think on a very basic level, I think that just the level of trust, for example, that you may have on institutional trust, the quality of the postal service. I mean, there are other things there, that are enablers for e-commerce, as making the UK a local market, that may not be the same if you want to send, you want to buy goods online in other places and you don't know if they're going to arrive or not. You don't know if you have a problem, with the seller, and things, for example, like consumer protection, speaking as a civil society and consumer representative in many fora. I think that one of the things that you need is consumers to trust that they are going to get the things they get, that they're going to be of quality, and that they have recourse. And I think that one of the problems you have with expanding trade cross-border is that many of these things start becoming a lot more difficult, to know what kind of, if I buy something from the US right now, you really don't have much recourse, if the seller sends you a faulty item. So, and that is still an issue. That's
really interesting. And forgive me, I've taken on question 3, so you're going to hear my voice a little more. No worries. And this question now, as I go on to question 3, I am going to address this to all three of you, just to be prepared. Now, this, I think we've begun to touch upon it, and I would be really grateful in each instance if you could think of how to answer the question about the issues, and we're talking about in relation to regulations. I mean, we're getting into the practical issues, but also what really interests me are the ethical issues here as well. I'd be really grateful if you could think about how to answer these in terms of the general principles. But I would be really, really grateful if you could bring these down to some specific examples of how this would affect either the consumer when we're talking about what needs to be regulated, or the business. So we could have some sort of concrete examples. This is as much for me as anybody else, because I need to get my head around how this affects people. Forgive me, as a layperson. So when it comes to regulation, and Javier, forgive me, I'll start with you for now. When it comes to regulation, what are the issues here? And then actually, in terms of examples, why do we need regulation in place?
I mean, I think that from the, narrowing it down to the main issues when we talk about digital trade now, and it's the two things that really come to the fore are the regulation of cross-border data flows of personal data, particularly, and the regulation of access and protections on cutting-edge types of digital knowledge, artificial intelligence, algorithms, and that sort of thing. I think that is, I want to use a very broad term because it's not, I don't want to talk even about intellectual property because it could be broader than that. So when it comes to data protection, the situation you have is that there are very different regimes around the world. And in some, everyone now is very aware that the digital technologies open the way for a lot of exploitation of the data, for people to know a lot about you, to use that information potentially to sell you things, to manipulate what you see online, to manipulate voting and things like that. And there is some digital is power. And the problem is that if you allow data to flow to countries that have got lower data protection regulations, once that the data is there, it becomes really hard to see, what will happen. And for example, in the US, which is notoriously right now the country that is the biggest obstacle, potentially even more than China. China just announced that they're actually going to tighten up their data protection, which from their point of view, I think, at least from the point of view of commercial data protection, is not a huge issue. The state surveillance is a different matter, But for the US, in the US, you can buy a database of people's emails and contacts based on their medical ailments, for example. So I want to contact people who have depression. I can actually buy a database of people that have depression. And that is the kind of thing that in the UK right now, it could still happen through some convoluted ways. There are, the ICO spends a lot of effort, trying to clamp down on, nuisance calls, all these people calling you, trying to sell you insurance. But there are, at least there is a framework to do that. Now, the question is whether we can bring other countries up, or whether we have to go down when we sign these trade agreements. And the problem you have is that many trade agreements, now they say that countries must have a data protection framework, which is good, but the bar that they set for those data protection frameworks is too low. And the concern is that the UK may be forced to accept lower data protections as equally valid as the one here. And there is a lot of discussion, on whether this is the case, how it will happen, and the details, but that is the concern. And that is, if you have to accept those frameworks and you are coupled with an obligation to actually not impede data flows, you have a bit of a cocktail, to stop to stop people from sending data to those places. And then moving quickly, because there is more people on algorithms, the main problem you have is that there are restrictions on what can, there are restrictions put in place, which in theory are there to protect technology companies from countries like China using regulation to try to steal technology, to say, well, you need to show us your algorithm because we want to check it to see that it's safe, when in fact what they want to do is actually to copy it and develop their own industry. Now, the problem you have is that in many countries, you actually need to see the algorithms. And this is a very, very broad, non-technical term I'm using, but you need to be able to examine modern technologies and barriers to that scrutiny in the name of trade can prove very problematic in many different areas, including like health or policing, you know, and face recognition, for example, by the Met Police, many things that could be quite problematic. So that those trade agreements could reduce the policy space in the UK. Yeah.
Thank you. That's really useful. And Sabina, could you add? I must admit, I find that these sort of practical examples are really, really useful.
Yeah, I think it's a really interesting conversation, and I think it's probably important to note on the personal data flows front, those are not regulated by trade agreements. The personal flow of data outside of the UK is regulated by the Data Protection Act based on GDPR. So trade agreements don't take away the high protection of personal data in the UK. They can't do that. There are legal mechanisms that companies have to comply with if they have to transfer data to a country that's not deemed adequate by the UK. So if you have a lower data protection standard, there are standard contractual clauses, other mechanisms that companies, you know, that create the legal framework for companies to be able to comply with the law, transfer data, and be held liable for the protection of that data. So I think it's an important conversation, an important kind of distinction to make. That personal data flow is not regulated by trade agreements. Now, the UK is in this position now of designing its new national data strategy, designing its new framework of international data transfers, and those, of course, will kind of connect to the trade agreements conversation. But that is a separate piece of law that is going to regulate how personal data is transferred outside of the UK if we change the mechanisms that we currently inherited from the European Union. So I think, you know, just make that point that that I think sometimes they're brought together and they're, you know, they're fairly distinct in terms of law application. Now, the new UK trade agreements that we've seen so far, right? Because most of them are rollovers, but we've seen new provisions on digital trade in the UK-Japan agreement. We have seen, obviously, this digital trade chapter with the European Union that the European Union never did before in its trade agreements. And we have some idea of what may be in that digital trade chapter with Australia. That's still kind of being worked out. And what we've seen so far is pretty strong provisions on consumer protections, on data protection, that, you know, Japan didn't have necessarily that language in its own trade agreements before the agreement with the UK. So I think we are seeing a commitment on our side for those high protections for both consumers and personal data that, you know, definitely industry supports, because you need trust in the digital economy and in trade for any business to grow. Now, those high standards, if they're only in the UK, it's not going to help us much. You know, because that would mean that you would need to kind of modify your product or service every time you need to kind of export it somewhere else. So that's why this international cooperation mechanisms that are kind of being developed in trade agreements, in digital trade chapters, and we are seeing an expansion of that mechanism of in more modern trade agreements of working with each other. That's not to say taking away domestic power to regulate. That's to say bringing people together, regulators together, policymakers together as they're developing new laws for the digital economy, that we work on those in some kind of conversation with our partners. So I think the more the innovations that are happening in digital trade agreements, you know, among Australia, New Zealand, Chile, Singapore, some of the countries that are at the forefront of digital trade innovation in trade agreements, are coming from exactly that area of, we are all thinking about competition, we are all thinking about keeping people safe online, we are all thinking about online content regulation, all these things that are on every kind of government's table among all our kind of trading partners. How do we kind of bring together that conversation and have those necessary discussions so that we don't all end up with like 20 different regimes while trying to achieve similar aims. So yeah, just to add that, you know, it's a long story of how do we get regulatory cooperation right without taking domestic power to regulate away, right?
Okay, thank you very much, and Dina, thank you for adding that. And Emily, please.
Thank you very much. So I'll build on the data privacy question. I'm going to add a couple of other public policy issues that I think should be on our agenda. So just building on from what Javier and Sabina have both said, yes, in the UK, we do have the GDPR. We have a high standard at the moment of data protection. I disagree, I think, with Sabina a little bit on the implications of trade agreements, because I do think they can have implications for your domestic regime. And they can do so because trade agreements now have provisions that say in them, in essence, allowing free flow of data across borders. You can introduce measures to protect privacy, and the agreements differ. The type of agreement we signed up with the UK, Japan then says those must be sort of necessary for achieving the public policy objective, i.e. of upholding privacy, and essentially not be more burdensome than necessary. If that makes sense. So yes, you can protect privacy, but we don't want it to be unduly burdensome for people doing trade and moving data across borders. What's really important, I think, for us all to understand, and this is there's a lot of experts disagreeing on this, it's quite a contested issue, but the EU in its trade agreements hasn't signed up to any general free flow of data clauses because it's worried that it won't be able to protect the EU's GDPR. So I know you've got another session in an hour on the defined points of this, but I think the key point is the EU's been very reluctant to sign up to precisely the type of provision we now have in the UK-Japan agreement, we see in CPTPP and others, because it's worried about the GDPR. So I think the question for all of us, and I actually think we need a little bit more research to really pin this down, is whether our GDPR, the UK GDPR, would withstand a legal challenge if brought under a trade agreement. And I honestly, I think it's quite contested. And because it's contested, I would like to see us putting stronger provisions in our trade agreements to make sure that we've got a cast iron situation where we know it can't be challenged. Devil's in the detail, as it always is with trade agreements, but I do think, therefore, the type of provisions that we are signing up to really, really, really matter on this question of data flows and privacy. And I'm happy to go in and sort of share more detailed analysis. Just build on this question of the regulation of new digital technologies like algorithms and source code. So again, trade agreements have got provisions, and rightly so, to protect the IP of companies, intellectual property of companies. But we've also seen, for example, we remember the A-levels data that were used, or the scoring for A-level exams was done with algorithms last year. There's a real question, is that fair, is that effective? Algorithms being used to screen CVs in employment, etc. So there's a real need, and you're talking, Liz, about sort of the ethics of this, of how we regulate these new technologies and how we hold them to account. So they're really powerful technologies, but at the same time, we really need to be able to hold to account these new technologies that use automated decision making. And again, the provisions in trade agreements here, the wording is what's really, really important. What we need to be very careful of is to make sure that we've got the future policy space, if you like, to regulate effectively. And actually, if you talk to technology experts, be interested to hear Sabina's thoughts on this as well, but they don't quite know what regulations we'll need in future. So we might need, so the EU, for example, is requiring companies now a sort of pre-screening. Before you bring an automated decision-making technology onto our market, we want to screen it and make sure that it's fit for purpose. If that screening requires disclosure of source code and algorithms, is that allowed under a trade agreement? It depends on the fine print and their wording. So I think that, again, the question is making sure we carefully craft these rules to make sure that we retain that kind of regulatory space and the right to regulate. And very quickly, and I'm happy to go into any of these in detail, but I wanted to put a couple of other bigger ones on our table as well. One is national security. So we're seeing a lot of countries now screen investment into critical infrastructure. Traditionally, trade agreements have facilitated cross-border investment flows. And yet, for example, in the area of 5G and critical infrastructure, we're sort of saying, well, do we want these investors in our marketplace or not? So again, there's provisions in trade agreements that have a bearing on that. We need to be quite careful about how we think about what we put in trade agreements. Another one is the regulation of the internet. So the trade agreements have provisions in them about content and intermediary liability, i.e. to what extent an internet service provider is liable for the content online. At the moment, they say nothing about online harms. I've not seen one that does. Do we want that? Do we want obligations in our trade agreements that sort of, if you like, increase the standards of internet companies being held to account for what they publish or not? Right. So that's another area, I think, where trade agreements are starting to have purchase on quite important areas of public policy. Just one more to add to the list is competition. So trade agreements traditionally have a big chapter on competition policy, but it's all about to what extent can governments intervene in markets, provide subsidies and other things. The big question for all of us in the digital space is the concentration and market power of big technology companies. Do we want provisions in trade agreements to actually cooperate and regulate on that market power? Again, big questions for all of us, but I think we need to be thinking about that as we move forward. So my last point on this is that we need a trade strategy for the UK on digital. So I think there's a whole lot of areas where there's really important public policy issues that are bubbling up in the context of trade agreements. And yet it's not clear to me that we've thought about exactly what our priorities are and therefore exactly how we should be approaching them. Because as you sort of intimated, there are important trade-offs and every country will approach it differently.
Thank you very much. I've desperately gone over my time, so I'll leave it now, but I think others will raise some of these points. Thank you so much indeed, everybody.
Yeah, thank you indeed. So let's move quickly on. The next question is from Tamara Jinjek.
Thank you, Chair. The question is, are the regulations on digital trade primarily domestic or mostly in the realm of trade regulation? What international agreements, if there are any, are appropriate for dealing with them? I think that some of that has been discussed already. Specifically, are free trade agreements the appropriate medium? And Sabina, if you could start on that, please. Thank you.
There we go. It took me a while to find the unmute button. That happened 30 minutes in. Yes. Thanks a lot for that question. So yeah, we have touched a bit, and I think, it kind of goes to the core of this conversation that, how much regulatory cooperation do we want in trade agreements, and how do you design a trade agreement in a way that it allows for these conversations to happen as Emily was saying, as new regulations or new areas of regulation, new technologies are coming onto the market. Do you need to review a trade agreement every 3 years to account for change in regulation or the digital market? So I would say that, as a kind of reality of technological change today, it kind of means that it's usually not tariffs that are the main barrier to digital trade, but regulatory divergence, right? So a bit touching upon what Emily was saying, what I was saying earlier, across a huge range of areas, governments, our government and governments around the world and across our trading partners are scrambling to understand the implications of new technologies and new business models. Cryptocurrency, fintech, what do they mean for banking system, ethical and legal implications of AI and autonomous vehicles, impact on social media, on elections, everything to do with emerging technologies and how much more complex they are going to get and pretty soon. So I would say a trade agreement is not necessarily the appropriate avenue to attempt alignment. What trade agreements can do is provide a framework for, I would call that maybe constructive engagement and cooperation between governments. So for instance, one of the really interesting innovations that happened last year in the Australia-Singapore Digital Economy Agreement that was signed in August last year is that agreement is accompanied by a memorandum of understanding on various technologies, kind of allowing a bit of trade agreement to be a living document and move with the pace of technology, allowing regulators to kind of keep in touch with each other as technology evolves, as maybe new provisions are needed, without actually having to review the trade agreement every once in a while. We think that's a really interesting model of doing a digital-only trade agreement that allows you to kind of keep an eye on every new technology and every new development as it comes along. But yeah, I think there is a risk that trade agreements become bit of Christmas trees if we try to regulate everything through trade agreements, which shouldn't be the point of a trade agreement. So it's mostly how do we create a context for regulators to be able to kind of keep having those conversations with each other as we develop regulation on technology. I hope that helps.
No, I think that's certainly relevant. What I'm hearing is that you're saying that a trade agreement might be out of step with the realities on the ground in the marketplace, and that you have to be agile because digital is agile and global. That's really helpful. Thank you, Sabina. Emily, could you come in on that point, please?
Yeah, thank you very much, Tamara. And I think it's exactly that. I think there's two aspects to your question. One is what should be done domestically and where do we need international cooperation? And then the second part is if we're having international cooperation, do we want it in a free trade agreement or elsewhere? So on the first one, I think the genuine challenge is that all of us as citizens in different parts of the world have got different preferences. So, we might have a very sort of high requirement for privacy here, and we've got to really protect our personal data. Other citizens in other parts of the world might feel differently. So actually there are different preferences. At the same time, businesses are going to do business across borders, and divergent regulations causes headaches for businesses. So they always get this tension, and it's right across international economic policy, if you like, where how do you square having these different preferences with the need of businesses to do business across borders. So the nature of the digitalized global economy, I think, means that we're going to need more and more international cooperation. So now even me as an individual, before I couldn't buy an iPhone from Japan, now I can, right? I can literally go online and buy pretty much anything anywhere. So individuals are participating in a global market space in a way that really we didn't have before, which means areas like consumer protection or even competition, where digital companies are now really global. Where they weren't before. So traditional areas of policy like consumer protection or competition policy, it's really hard for them to be effectively done just at a national level. So actually, I think the digitalization agenda sort of speeds up the need for international cooperation, for international coordination. At the same time, it doesn't get us away from the fact we've got very different preferences. Sorry, it's not an easy one to square.
No, but that's really interesting, because therein is the nub of the issue.
And we need that cooperation and coordination. On the second aspect of it, Mara, just very quickly, free trade agreements are a powerful, generally international trade law is the mechanism we have for internationally binding legal with sanctions, right? So it's codified, quite hard law, as opposed to kind of regulatory cooperation. And in general, in new areas, I think Sabina's right, you want more sort of cooperation and dialogue than a sort of codified system before you quite know what you want. So in areas, so that in that sense, I think more memorandums of understanding, regulatory cooperation make more sense than hard law. That said, I think we need to take a step back and look at where trade agreements codify and give quite hard, stringent rights. For example, on intellectual property, they're very strong. On sort of reining in state governments from intervening in the market in certain areas, they're very strong. They do very little on consumer protection or on competition. So already we want to be thinking about the fact that they strengthen some parts of the digital economy, and arguably for the large, powerful companies are more advantageous than for smaller businesses and for consumers at the moment. So I think we need some rebalancing in the way that we approach it.
Thank you. The IP question is something that's come up in my sector with the fashion industry, so post-Brexit, so that's very relevant. Before I hand back to the chair, do our other speakers have any comments?
Yeah, I would like to add up. I think that in terms of domestic or international, I think that, that has been explained, but something else that is important about digital and the impact of the internet is that traditionally, when you look at trade or industrial regulation, you're regulating companies, and you're regulating, how companies operate with each other, you're exporter, importer, and even, you're regulating more broadly beyond trade, you're regulating freedom of expression of media, you're regulating newspapers, you're regulating TV stations. The internet, you are regulating because of the way that individuals can contribute and buy directly or sell directly. You end up regulating individuals, and you are entering the realm of personal rights much more strongly than in other areas of industrial regulation. So that is one aspect that cuts across not just digital trade, but digital everything. That is a particular issue, and that brings new problems. And then in terms of the free trade agreements, just following on what was said about IP and trade, actually, that was what Emily was referring to didn't happen by accident. I mean, that was a very deliberate effort by pharmaceutical and large US media companies 30 years ago, almost 25 years ago, to do what is known as forum shifting, which is to take the regulation of IP from the World Intellectual Property organizations to a forum where their rights could be more protected, because Emily said, as Emily said, they are enforceable. So there was a deliberate attempt to bring IP from the other international bodies to the WTO with the TRIPS agreement and others, specifically because they could be enforced. And I think that the problem we are seeing now is that there has been already a 25-year process of trying to regulate the internet at the Internet Governance Forum, other places, very imperfect, very problematic. Now what we are seeing is a forum shifting to try to bring internet regulation to the space where companies have more power and where their interests can be protected and enforced. And that is a problem for consumers in general, the idea of moving forum shifting to trade.
Yeah, it brings up a lot of issues around SMEs versus big business as well. Thank you so much. Because of time, I'm going to defer back to the chair for the next question, but thank you everyone for your answer.
Thank you very much, everyone. Yes, we must move on. We have a rather tight constraint. So the next question is Paul, MP. Paul.
Hi. And
I'm in a Zoom meeting, but don't worry, you carry on.
Sorry, I think Roger's unmuted. Obviously, there's been a lot of overlap between the questions so far, and I want to try to hone it down. I'm very conscious of time. Emily made the point about the need for trade strategy for the digital trade strategy for the UK. And I wonder if, kind of thinking of the UK's main trading partners in Europe and beyond, if you could highlight the most significant barriers to digital trade, and those which you think that the government should prioritise in any trade negotiations, perhaps starting with Sabina.
Thank you very much, Paul. So I think the countries that we are currently negotiating with, or almost done negotiating with, whether it's Australia, New Zealand, Japan, that's already been done, the EU, these are partners we agree on. We agree with on a lot of things. So these are, you know, when it comes to digital trade, it's mostly about kind of bringing together and you know, adding another voice to the chorus of kind of a free and open digital trade conversation that's happening in the WTO as well. So it's less a matter of, you know, we have restrictions that we need to take down, and more a matter of we need to join the club of these countries and have digital trade chapters that are aligned with kind of best international practice from that point of view. Now, there will be conversation coming down the line, you know, whether it's the US and if that's ever revived, whether it's India for that matter, there will be trade negotiations coming down the line that will be a lot more difficult when it comes to digital trade because of public procurement laws in the US, for instance, because of data regulation in India, you know, that for those of you that may not be aware, you know, significant provisions in their national law that discriminate against foreign companies, data localizations, all the things that you know, us and our international partners don't stand for. So there will be conversations that will be difficult further down the line. I think India will be a very big initial test that, you know, will start at some point, and that will be kind of the first time probably as a tech sector that will actually find that negotiation difficult, and we'll have to navigate that carefully because there are significant restrictions there, and I'm not sure that, you know, India is about to kind of diminish some of those for us. So there will be a difficult conversation there. But other than that, with, you know, Singapore, Australia, New Zealand, you know, the EU, Japan, and our attempt to join the CPTPP, I think we are on fairly safe ground there. It's more about kind of, you know, building up that block of countries that work together at the WTO and that have a coordinated kind of common voice, hopefully. So yeah, just a few points there.
Thanks for that, Sabina. I wonder if, Javier, you could share your thoughts on the issue.
So I mean, I think that as Sabina has identified some of the key issues in the big agreements, you know, with India, you know, like where they have a very clear national strategy to protect their digital economy, you know, it's like almost like digital, like almost digital, like a digital nationalism, you know, idea, and the US with procurement. But I think that to be honest, if you want to really look at the barriers to digital trade, you almost need to take one step up and look at the trade sitting, as we said before, the digitalized economy, you know. So it's not just the barriers to the digital sector or the cloud sector, you know, to tech companies, you know, but how, for example, all the services that are going to be accessible, you know, like trade commitments on services and wider regulations, for example, you know, if things like being paid, for example, you know, I mean, I work as a consultant, you know, and I work with countries like, for example, like Mozambique, Georgia, Zimbabwe. I cannot get paid through my bank, you know, for example, you know, that's because of financial regulations elsewhere. So there are quite a few other things, you know, before you get to the barriers on data flows and, you know, like the new digital trade issues, you know, where you have to look at more broadly trading services, how digital services fit there, you know, what other arrangements are made, you know, on competition, as we said, you know, like financial regulation and other areas, you know, before you can look at what the actual barriers are in practice. But then what I would say is that there is also, I mean, in terms of the main trading partner, I mean, the EU is still, pretty much the main trading partner. And the concern that many people have is that opening up, the more that the UK tries to become almost like an interoperability hub for data flows, where they can bring data from the UK, but also create new innovative arrangements, with other countries potentially. I know this is something that DCMS is working on right now. There is a danger that at some point you start breaking your relation with the EU, and that, of course, that would be quite a big barrier to trade potentially. Yeah.
Okay, many thanks. It's absolutely fascinating, and I would like to press further on some of those points, but I'm conscious of time, so I'll hand back to the chair.
Indeed, thank you very much, Paul, and everyone. So the next question is Stephen Farry, MP. Stephen.
Thank you, Chair, and good morning, everyone. Similar to Paul, I suspect this question has been touched upon in many of the previous answers, but just to try to narrow it down a little bit more. The question is the UK better to develop our own regulations or to work with groups of other countries to do so? And that's directed primarily to Emily and Sabina.
Thanks, Stephen. I think it's imperative, actually, that we all work together and that regulators really share their best understandings about how to approach this. To give you one example, competition policy at the moment, it's really hard for competition authorities to figure out how to regulate to make sure we've got a competitive, vibrant marketplace, because the traditional ways of regulating markets just don't quite necessarily translate into the digital world. And actually, what's really important is to make sure that we're sharing best practice and sharing across jurisdictions. So we need a huge amount of regulatory cooperation. I think in just about every sphere of this. How do we regulate new technologies? How do we make sure that we've got effective standards of data protection? We essentially, in this digitalized world, we can't live without international cooperation. I think the challenge comes for us, and this is again sort of the point I made earlier about the UK having a strategy. Everyone's got slightly different preferences when they come to take the table on this. Governments have got slightly different preferences. The companies, large or small, depending on their business, have got different preferences. And the challenge for us is to cooperate and find ways to cooperate that advance our priorities, if you like, as UK citizens. And so we need a domestic conversation about what those priorities are, and then to think about how we pursue them cooperatively internationally. And my concern is I don't think we're having that conversation domestically yet. And that, I think, means that we're approaching our trade agreements in quite a transactional way. So we're sort of saying, well, what does our trade partner want? Well, maybe we can be agile. There's a real risk, I think, there that our wider priorities we might lose sight of what we're really in it for, if that makes sense.
Sure, thank you. And Sabina?
I'll just very briefly add there that the UK, has been at the forefront of putting together and coming up with innovation-friendly regulation that maintains public trust and safety. So whether you're thinking of the development of the open banking under the leadership of the CMA, and that has played a key role in kind of the growth of the UK fintech sector, whether you think of the Financial Conduct Authority's regulatory sandbox that has already helped something like 140 companies test innovative technologies and products in markets with real consumers. And it's kind of in the AI sphere, whether you think of the creation of the Center for Data Ethics and Innovation, which is the world's first such thing, nobody else has it. Which is dedicated to kind of helping UK's use of data and AI and kind of create that global leadership in that space. So if this innovative regulatory approaches that the UK has developed leadership in are not replicated elsewhere, we are a bit stuck. It kind of goes back to the point that I was making earlier, that means that UK developed technology, services, products will need significant modification to enter other markets, right? So I think the UK comes with a wealth of actual good practice for this regulatory conversations and this regulatory cooperation conversations. And we've heard that from our trading partners over and over, especially like, the ones that I mentioned, the Australian and New Zealand, the kind of countries at the forefront of this conversation on how to do good, decent digital trade policy, that these are really interesting innovations. These are really interesting things that the UK is doing. How can we kind of have more conversations of those? So I think it's there is UK leadership in the space, and I think that UK leadership needs to kind of find sounding boards and partners for those conversations to happen. So I don't think we're kind of completely lost in this trade discussion, and I think it's maybe a little bit unfair to kind of describe the UK as just a copy paster of trade agreements that have already been done, because we've seen already, and I think when we see the text of Australia, we'll already see some of the actual UK strategy coming out, as opposed to kind of a bit of the CPTPP text in the Japan agreement. But even there, like, we have open government data provisions coming out of the kind of USMCA discussion, slightly further afield, that's kind of introduced there, things around e-signatures and paperless trading that that were actually UK government provisions that they pushed in there. So I think, we are getting there. It's a nascent conversation, but I think yeah, the UK is definitely kind of has stuff to bring to the table, and it's good it is doing that.
Thank you very much, both of you, and back to you, Chair.
Thank you very much, Stephen. As a final question in this session from Peter Norris. Peter.
Good morning. I think Sabina's probably covered quite a lot of this, but the question is, as the UK looks to develop its digital trade policy, could you pick various countries whose example you think we would be well advised to follow? And by the same token, are there any countries whose example we would be even better advised not to follow? Emily, would you like to start on that?
Sure. So I think Sabina's already mentioned the sort of those that are at the forefront of thinking about these issues. There's Australia, New Zealand, the Singapore, Chile. They're probably at the forefront of putting things in trade agreements and creating space for this conversation. I have to say, I'm always very resistant, sitting in a school of government and public policy, for us to ever take any sort of template and say it's going to work for us without us really thinking, well, what are our strategic priorities? And actually, particularly on the data one, I am interested that Australia and New Zealand have not got the type of system and don't have adequacy from the EU. So I think the data privacy one is a little, they've not got such a stringent system as we do. So I do think on there, there's a real question in my mind as to whether they've got a system that we want to emulate or not. So I think that's probably the one question I have. Otherwise, I think that those are really interesting for conversation. The bigger point I would make is that I think all of this needs to be much wider, more public. At the moment, a lot of what's going on in trade agreements happens behind closed doors. And so I know, Sabina, I was talking to a journalist the other day, I was saying, oh, techUK knows all the details of this, and it's brilliant that, Sabina, you're there and that industry's there. It's a really important voice. But my concern is it's not everybody else is at the table. So I can sort of, the citizens groups, the civil liberty groups, they're very concerned about data and privacy protection. They don't necessarily have the same oversight of what's going on in the negotiating room. And these things are just too big and important to be left behind closed doors to just a few voices and a few perspectives. So a real push, I think, from my side is just to open up this policy making space so that we can actually have a much more informed, evidence-based discussion.
Thanks, Emily. Javier, have you got anything to add?
Yeah, I think that pretty much agreeing with what Emily said in the terms of transparency. I mean, I am actually in an expert trade advisory group for IP, where I have to sign a non-disclosure agreement to have access to the documents. But the one on digital trade, I used to be in one on digital trade, but then it was made industry only. So I think that what Emily was saying, is actually quite important to have a broader participation and a lot more transparency. And actually, in that sense, if you look at the European Union, which is presented as a model of opacity in this area, there is a clear process for how trade policy is made, and they have things like data clauses, for example, that they will put in most trade agreements except the UK. So there are some good examples in participation. What I would say about New Zealand, I was thinking, about this question before. The one thing, for example, that New Zealand has that is interesting is that they do have a policy for bringing social and environmental consideration of things like the impact on Maori groups. Oh, Alexa, stop. That was the alarm there. So you have some processes somewhere, for making a trade policy. I mean, for making sure that trade policy brings in social considerations, although of course the devil is in the detail, as we said before. So we need to see how that is managed. Yeah.
Thank you very much. I'll hand it back to the chair.
Okay, thank you very much indeed. That concludes the first part. Let me thank Sabina, Emily and Javier very much. It's been, well, almost too much to think about. This is a very exciting and very complex field. And so thank you for helping us try to sort it out. I'm going to hand over now to Alison Williams, who's going to oversee the second part of our meeting. So Alison, can't see you, but I'm sure you're there.
I am. Thanks, Alan. Yeah, so I'm Alison Williams. I'm one of the commissioners for the UK Trade and Business Commission. I'm also global head of data at dunnhumby, a data science company. Yeah, absolutely fascinated by everything that's been discussed so far. So thank you to our chair and to the first three witnesses. I'll be chairing the second part of today's session. So what we really want to do now is kind of get into some more detail around some of the mechanisms that have been talked about already around things like data adequacy and UK regulations and really around the flow and use of data across borders and how that's going to already has impacted trade. So I'm going to start by asking the four witnesses that we've got for this session to introduce themselves. And I will start with Adam, if you're there.
Yes, hello. Thank you for having me. I'm Adam Bowering. I'm a policy advisor in the European Parliament, and I worked on the European Parliament position on the data transfer agreements with the US and with the UK.
Thank you. Thanks for joining us today. I will next go to Nick and start with a huge thank you for joining us at a very early part of the day. I think you're in New York, if I'm right, Nick?
I am, yes.
Yeah, thank you so much for the early start.
Yes, you're very welcome. I'm Nick Ashton-Hart. I am the Special Advisor for International Internet Policy, pardon me, at the International Chamber of Commerce and the Geneva representative of the Digital Trade Network. I follow trade policy for the private sector, but I also provide technical assistance in the negotiations, the 85-country WTO negotiations in Geneva for developing countries.
Great, thank you. Thanks for being here. And have we got Duncan?
Yeah, hi, thanks everyone. So yeah, I'm Duncan McCann. So I currently lead the digital economy team at the London think tank, the New Economics Foundation. And before that, I also worked for 10 years for Cisco Systems.
Thanks, Duncan. And Jim.
Hi there, I'm Jim Killock. I'm Executive Director of the Open Rights Group. We work on all kinds of digital issues, particularly those that affect free expression and privacy. And we have 20,000 campaigning supporters.
Great to have you here. Thank you. So I'm going to kick off the first couple of questions, and I'm going to start by focusing on data adequacy. So I'll ask the witnesses if you can just explain what does data adequacy mean, how does it differ from where we were previously in the single market, and really what does it mean for UK? Do we need it? So if I could go to Duncan for the first question, please.
Oh, great, thanks, Alison. So yeah, so I mean, I think broadly, I think an adequacy decision is a rubber stamp from the EU that we have kind of essentially equivalent rules here in terms of how we manage data, and then that opens up the opportunity for a freer flow of data between the UK and the EU. So I think that's the core of kind of what adequacy means for us. And obviously we also now within DCMS have a process to certify third countries ourselves to be adequate with our own data protection regime. So we've kind of adopted that process within the UK. In terms of thinking about what the difference is between what we had kind of prior to Brexit and what we have today, think of what we had within the single market of a kind of an unconditional, stable, permanent kind of mutual agreement about how data would flow, where that was kind of set in stone, as I said, unconditional and permanent. What we've moved to with adequacy is something that is conditional. So it is only going to be accorded to us if we meet the requirements set out by the EU institutions. And indeed, even the EU institutions between the Commission and the Parliament and the Court see granting of adequacy in a kind of different context. So it's really important to see there's not, in this case, there's not one homogenous EU. It's important to think about which institution or a part of the EU that we're talking about. It's temporary. So the UK has been granted the first ever adequacy agreement with an end date. So I think that's really meaningful. And also it's unilateral. So whereas before we had something where we would have taken both of us, the EU and the UK, to kind of change that arrangement. Right now, we're at a place where the EU can unilaterally change that at the drop of a hat, as we saw with the EU. And again, it's not just down to the EU Commission that grants the adequacy decision. They could obviously remove it unilaterally, but also we're subject now to the courts. And obviously, as we saw with the US agreement, which was challenged through the Schrems case, the UK agreement is equally likely to fall potentially with an EU court judgment. So we've really gone from something really stable that we can rely on to something much more loose. That, especially as businesses looking for certainty going forward, that risk is much greater. And then finally, just on does the UK need adequacy? As part of a kind of study that I did together with Javier and others, we did over 60 interviews with experts, and literally nobody voiced the opinion that we don't need adequacy. Adequacy is something that we absolutely want. The relationships that UK companies have built up with EU companies in terms of data transfers are really complex. And indeed, many companies are not even fully aware of all the data that's flowing between one and the other. And so losing adequacy would have required a huge amount of work. And so we looked at some work about what would some of the impacts be of the UK losing adequacy. And we very, very conservatively put the figure that UK companies would need to engage in at least £1.6 billion worth of compliance costs. That burden would fall disproportionately on the SME community, a community that really can't bear any more strain, especially as we exit a pandemic and businesses need all their cash to invest in staff and recovering from the pandemic, not engaging in compliance activities, which gives them nothing other than to stay at that same level. And then just also important to realize that the impact is not just from those direct compliance costs. If we lost adequacy, it also has the potential to reduce EU-UK trade, especially the digital component of that. We could potentially see reduced investment, and that's both domestic and international. And then importantly, we also heard from many of the interviewees that we could see relocation of business functions, infrastructure and personnel from the UK to the EU. So really, we do really want this adequacy, but it can't come at any cost. Like we actually have to, it has to be because we actually really meet the conditions that adequacy require. And maybe we'll go into some of those details later, but thanks.
Thank you. Yeah, those potential impacts really ring true for me, and the potential cost as well. I know a lot of people were celebrating when that ruling came through around adequacy. Thank you. Adam, do you have anything to add to kind of bring this adequacy status to life?
Yes, so I completely agree with Duncan's very comprehensive response. I would add that it's important to note that the adequacy arrangements in the GDPR were negotiated in a context of the Snowden revelations, which UK actively participated in these mass surveillance operations, and negotiators were very aware of that, and that's why these adequacy decisions were designed in the way they are, with such stringent requirements. And as Duncan was saying, from a business perspective, gaining adequacy now may appear good, but it's not a long-term solution. The European Parliament has form in objecting to adequacy decisions. It objected to the adequacy decision with the United States, and it's objected to this one with the UK. But for valid reasons. I mean, it's found that the Commission has not properly evaluated the data protection situation in the UK. There's the problem of the immigration exemption, which was declared unlawful in the Court of Appeal recently. ECHR has also recently found that UK mass surveillance law violates the right to privacy, and there are problems with bulk collection and retention and onward transfers to countries like the US, where the adequacy agreement was recently invalidated. And because of this, as Duncan mentioned, the Commission has made unprecedented changes to this adequacy decision with the UK. It's very time limited to 4 years. There are review mechanisms. There's a carve out of immigration law, but these in themselves create new problems which make the agreement more unstable. So in addition to potentially being withdrawn by the Commission at a later date, this adequacy agreement could also be declared invalid by the courts because of the reasons outlined. So for mass surveillance, there doesn't appear to be a full evaluation of the new Investigatory Powers Act or Schrems, another case law. The carve-out may not actually be applicable in practice, and there's issues of onward transfers and potentially divergence from the GDPR, as we saw with the task force on innovation report. So all of these create issues that will potentially undermine the business situation and their reliance on, as we've said, this seamless flow of data to prevent burdensome standard contractual clauses and binding corporate rules.
Yeah, we've definitely been left in a very precarious position, I think it's fair to say. Thank you. Jim, is there anything you'd like to add?
Just on the instability point, the one bit we haven't addressed there is the nature of our enforcement body, the Information Commissioner's Office, and I think it was highlighted by the European Parliament in their commentary on this adequacy agreement that the Information Commissioner had failed to enforce against the abuses of the ad tech industry for over 2 years. That's a complaint that was brought by myself and Michael Veal against the, to ask the Commission to investigate and to enforce against that industry. Those abuses have not been rectified. There's still no sign of them being rectified. The ICC has taken no action. If the Information Commissioner is not enforcing GDPR, then it is meaningless and adequacy can't really be sustained. So we really need to look at the quality of the enforcement of GDPR in the UK. I'm afraid the government is pushing signs in the opposite direction. It wants less enforcement, not more. It wants to weaken the rules. It's appointing an information commissioner specifically on the basis that they will promote data sharing rather than somebody who has an expert in enforcing the rules. And they've, in both the national data strategy, the DCMS strategy yesterday, and in papers that the government has produced in the last few weeks, indicated that they want to remove protections and increase what they call flexibility, which to my mind says, basically gut the rules, make them less compatible, allow all kinds of dodgy businesses more freedom to engage in appalling data practices in the name of making money, and none of that says adequacy to me.
Thank you, and that actually leads really directly onto the next question, which is what the adequacy status really means for the UK in a broader context. So, trading and working with countries outside of the EU. Is it compatible? And do you think that the UK government is going to need to stick to the adequacy ruling and the obligations that comes with that, or diverge from it? So, Jim, maybe do you want to carry on, since you're kind of touching on that already?
Yeah, the deals, the specific risks in the deals. There are a few, right? One is that using the adequacy agreements system that we've already got, the UK saying they want to rush these through, that it wants to do them quickly, that it's got fed up with the EU taking so long, and so now it's going to just make these agreements quickly. If that turns out to mean not very good, well thought out agreements that don't agree easy data flows with countries whose data protection systems are actually pretty bad, well, then the EU's just simply got to look at the nature of the EU's adequacy agreement and change it, because European data would potentially flow into UK and then out of the UK to these other countries where it wouldn't be sufficiently protected. So I think the UK's ambition there, is risky. Let's put it that way. And then we have the other side of the coin, which was being discussed in the previous panel, which is this whole question about the risk of essentially trade challenges, trade legal disputes with the UK about us operating adequacy at all, and whether that really is the least restrictive method of protecting privacy in data flows. I would characterize it more strongly than Emily did, in that I'm not really aware of there being a lot on the side of saying that we really would be able to sustain that. What I think has been really bad about the debate around this particular question is the government just repeatedly denied that there's a problem, says that there aren't any real risks of trade challenges, and therefore we can ignore this. I don't think that is sustainable. It's not even in the gift of the UK government to say that, really. I mean, if the risks are there and other people wish to challenge it, then they will. So really, we've got to look at who we're signing agreements with and whether they're likely to want to engage in a dispute. I think the big issue with some of these agreements, particularly the CPTPP, is that there are many, many partners. New partners may come in. So the risks of legal challenges there are very, very significant, not least because those countries generally don't have high standards for data transfers and have a lot of good reason to wish to push the UK standards down. So, yeah, I think we're leading ourselves into a lot of trouble here. I'm sure other people have other things to say on that.
Thank you, Jim. Nick, would you like to just add to that?
You all are a hard act to follow. There's not a whole lot more. There's a whole lot more I can add to it. The one thing I will add is there's an interesting idea. This question of can the UK's adequacy system is very slow. Countries wait years for an answer one way or the other. There's an interesting idea of could we be attractive in our trade agreements to other countries to come to an arrangement where their data can flow to us, and if we put the right obligations on them through to the EU and to other partners, maybe something of a data hub, if you will. There are a lot of complications with this. Jim has just highlighted several of them, but it would be an interesting sort of competitive advantage question if we could, the extent to which we could do this, because there are a lot of countries which do want to trade with the EU, but cannot get an adequacy decision, and they're then in a trap where anyone who does business with them is taking on a great deal of additional risk in terms of what might happen to them in the EU if there's an incident. So I don't think that the government has thought very much about this. I think probably because it's busy doing other things, but that's always been a question I've been interested in, because we could kind of have our cake and eat it too, to an extent, with this, and become an attractive inward destination for data, with all of the caveats that apply in terms of protecting ourselves and protecting our own adequacy decision, given the fragility that's already been mentioned.
Great, thank you. Adam, anything you want to add on top of these comprehensive answers?
Yeah, I mean, the key issue is really onward transfers, because while onward transfers are allowed under the GDPR and case law like the Schrems judgment, they should not undermine data protection, and data protection should be held to the same standard. So, as we've heard in the last panel, and as the Commission decided that there was no issue with the onward transfers that the UK is currently trading with. I think this argument will become more and more difficult as the list of countries that the UK has agreed to trade agreements with expands. 8 out of the 11 members of the CPTPP haven't agreed adequacy agreements with the UK. So this has already been flagged up as an issue by the European Parliament. So this is something in particular that I think will be an issue. And as to should we diverge? I think it's clearly a resounding no. I think that's probably clear. There's important ethical reasons for the GDPR, but from a business perspective, it facilitates trade, and it's enabled the harmonization within the EU, and the UK clearly benefits from being part of that. I mean, 75% of the data transfers from the UK with the EU, so it's important to make sure that continues.
Thank you. That last stat really brings to life the importance of this and just the weight of our involvement with the EU compared to other countries. Okay, I'm going to hand over to Hilary Benn MP now for the next question.
Alison, thank you very much indeed. What's really striking listening to the evidence this morning is different countries in different parts of the world have different considerations. Some are very worried about security when it comes to the exchange of data, others about privacy. And I was very surprised to hear Javier say in the first session that in America you could buy a list of people who were suffering from depression, which is kind of rather relevant in view of the decision that individuals are making in the UK currently about whether their own anonymized data should be used for research purposes, which I must say I support. My question really is, and maybe start with you, Nick, is given this, is there any prospect of a global agreement on the rules governing data flows and data transfer in the near future, medium term, long term?
Great question. I actually, as I mentioned, I think I sit in the room where the 85 country negotiations in the WTO are focusing on a very broad. The agreement covers a very broad range of subjects, and the core of the agreement is actually a politically linked and practically linked set of 3 subjects, which is international transfers of data, the localization of computing facilities, and data protection itself. The second being, shall the parties to that agreement be prevented from requiring the hosting of data or other computer services in their territory as a condition of market access. And this is closely linked to data protection because there are quite a few countries in the world which actually require data to be localized in their jurisdiction of their nationals for certain kinds. Health data in Australia is an example of this. This is the heart of the agreement. It's also the most difficult issue, and it will be the last one solved as the agreement is negotiated. I think it is possible at a trade level to have an agreement on this, because trade agreements are not very specific on how you go about meeting your obligations. There's a good deal of flexibility built into them. And there is, I would say, a pretty general view amongst the countries that they don't really want the further development of their data protection frameworks to be the subject of a dispute at the WTO. They all want the freedom to evolve their data protection frameworks over time. Of necessity, yes, I think there will be an agreement. It's probably 18 months away, I would say, honestly, something like that. But it won't solve lots of the practical day-to-day problems, because even if there is an obligation to allow data to flow as part of the agreement, there already is such an obligation in the WTO. In the telecommunications annex, if you make a commitment that requires data to flow in order for the benefit of your commitment to be enjoyed by another WTO member, you must allow data to flow in order for that commitment to be realized. So if you make a market access commitment, say in accounting services, for example, and you say, I'll allow accounting services to trade in my jurisdiction from any other member, obviously data related to accounting services would have to be allowed to flow also, which obviously includes personal information to some extent. So I think there will be a broader commitment in this area, but it will still be up to each country to decide whether or not their nationals data flows out and under what conditions. None of the members are going to constrain their rights in this area. The EU is adamant about it, but they're far from the only one. So I don't think trade is where you're going to find all of the answers. You may limit the ability of countries to make very broad barriers to data flows, or to create obstacles in terms of the localization of data and computing facilities, but the actual execution of how the other members enjoy that benefit is still going to be left to information commissioners and regulatory authorities in the various members. And I'm sure there will be some cooperative function that is part of the obligation of the parties in order to facilitate that the benefits of the agreement will actually be realized. But historically, the cooperation sides of trade agreements tend to be of limited utility at a practical level, often.
Okay, that is very clear and extremely helpful. I just wonder whether any of the other witnesses want to add anything to that.
I mean, notwithstanding the notwithstanding the problems with the US regarding the Schrems decision and US surveillance law, there is discussion at the EU level on a transatlantic alliance, particularly on data issues between the US and the United States, and as the prospect for privacy law in the US increases. I think this is looking increasingly likely given the shared values and interests between the EU and the US. So I think the UK could form a part of that. As we've seen with Vice President Kamala Harris has been very strong on these issues, having adopted the California Privacy Act under her administration as Attorney General in California. This would be an alliance which would be very important for the UK to be a part of. I think there are obviously different approaches to data protection, and but 120 countries have now adopted privacy laws, partly thanks to the path forged by the GDPR. So I think it's important for the UK to be involved in whatever alliances are created.
Okay, thank you. And just following on from that, what's also very clear from the evidence today is that, as in many areas to do with our future relationship with the EU, the government has to make a choice about where it sees the balance of advantage. And given that the data adequacy decision we've been given is A, temporary, and B, can be withdrawn if the EU thinks we've moved away, would anyone like to comment on looking at the future potential for further growth in digital trade? Where do you think this government, or indeed any government, might see the balance advantage? More digital trade, but at a price of moving away, which will then impact upon the cost of doing business with Europe, or to stay closer to the European model because of the benefits that gives us? Nick.
Thanks very much. I think the reality is you want to have a high enough standard of data protection that you can share data with every other jurisdiction. Basically, you may not try to, you may not seek adequacy with those jurisdictions, etc. But if you're an advanced economy and you're in our position in services number 2 in the world, you're going to pick the highest standard that allows you to work with everyone, and that's the EU. So diverging from that doesn't really get us anywhere, because other countries are converging on the EU standard, even somewhat unwillingly, where they're developing countries, and this creates a real burden for them. So the higher in this data protection racket, it's not really a racket, but you know what I'm saying. If you want to trade with everybody, you pick the highest standard, because it's just that's just much simpler.
Okay, I think because of time we need to move on. Thank you very much.
Can I make a couple of?
Oh yeah, just Jim, very quickly. Yeah.
Yeah. So I think the thing to realize here is not a binary thing, right? If you it's not less regulation equals more trade, it's or more business. It's less regulation equals a certain sort of model. So the sort of model you have in the States where data can be traded freely, where abusive practices emerge, where the things you see online end up in the insurance market for what insurance you're entitled to. That's one model. And yes, there's a whole raft of businesses there which couldn't operate in the UK. But you have to ask yourself, do you want those businesses in the UK? And is that a good thing for the kind of economy you want to develop? I would say it isn't, because it just increases discrimination, it increases exclusion, all kinds of outcomes we wouldn't really want. There might be some economic growth attached to that, but there's also going to be increased poverty and inequality as a result. So, okay, you know, you make your choice, basically.
Okay. Jim, thanks very much. Back to you, Alison.
Thank you. And yeah, I really love that last point, Jim. It's really important to call out that trade and economic growth and protecting citizens' rights are not mutually exclusive. And definitely we would want the government to find a way to respect both. So we'll move on to the next question with Professor Shira West, please.
Thanks very much, and thanks to all the witnesses. I mean, I've learned an enormous amount from this session, and this area is so complex. So my question is about regulation, which we've talked about a lot, and I think I'm beginning to infer what the answer to this question is, but I'll ask it anyway. So national regulation of digital services is growing, and how should the UK approach this issue to balance consumer and business interests? And I'm going to go to Jim first.
Well, I think within trade agreements, the key thing is not to constrain your ability to regulate. That I think is the most important thing. And the previous panel highlighted two major areas where this constraint may occur. One is in data protection and data flows, and the other was in algorithmic judgments and access to algorithmic information. And of course, as judgments are made about people, or public policy outcomes are calculated by algorithm, all kinds of things like that happen. You kind of need to know how these algorithms work, and they are, after all, only a formula, right? So kind of closing off access in that way has public policy potential, for bad things to happen. Also, it was highlighted in the previous panel the idea of things like online harms and speech regulation being constrained within trade agreements. And I think the point that Javier made is a really important one here, which is in each of these areas, you have a human rights impact, whether it is speech or privacy or other kinds of rights impacts. And using a trade mechanism to constrain how that is dealt with means that you have to have effectively the least rights friendly, the most trade friendly approach in those areas. And that may not be the kind of society we want to develop. So I think it's really important, where there are essentially human rights implications, to try to keep those things as flexible as possible and as little impacted by the trade agreements as possible. There's also issues of fossilization and so on that come from this. And I think you see that in intellectual property law, for instance. Essentially, the constraints are now so high. If we want more flexible areas around intellectual property, it's actually extremely difficult. You think about things like copyright term, where it's an author plus 70 years. I mean, that may be at some point considered a little bit long, and maybe not appropriate. But unfortunately, trade laws just bind us into that. It's very hard to change.
Thank you. That's really very clear. Duncan, do you have any comments on this area?
Yeah, absolutely. I think it's really important to say our kind of key national regulation here has now been in force since 2018. And obviously a lot of companies, even like the charity think tank that I work for, we had to engage in a lot of compliance activities when that regulation came in, when that law came in. However, the Data Protection Act remains chronically under-enforced or unenforced when it comes to kind of business as usual practices. What we've seen is kind of big leaks, big kind of problematic one-time instances. Some of those have been legislated for, but some of the real big questions kind of remain unanswered. So for instance, like in a personal capacity, I have launched a legal case looking at the legality of collecting children's data, so a case against YouTube. And indeed, the law says that platforms need to get a special form of consent from the parent or guardian in order to collect the data of children under 13-year-olds. And yet, you know, that is, from our perspective, not done really anywhere across the internet. And so what are the implications of these kind of regulations being technically on the books, but not being enforced? What does this mean for the companies? And I think the other big example, you know, from a UK perspective is the one that Jim brought up earlier. This whole way in which we deliver advertising over the internet is widely believed to contravene the data protection rules, but is not being enforced. So what does that? So again, when we're looking at these national regulations and trying to balance, and it's a complex question because these are fundamental practices that businesses have been engaged in for years now. And indeed, the way we do advertising or the way that these platforms collect either special category data or children's data, all predates the kind of the regulations that are in place today, but we haven't really caught up with that initial regulation. And so I think it's hard to see how we kind of move forward. And in some ways it's been exciting with, you know, the ICO trying to go a bit further on, you know, children's rights, although obviously there are some issues with the way the age appropriate design code was implemented and potentially being enforced. I think, yeah, we've got this challenge of a kind of core regulation that's unenforced at the moment, which leaves businesses doing the right thing, suffering an additional burden compared to those willing to take the risk and kind of flout the legislation. And again, it goes a bit to Jim's kind of statement. What kind of businesses and business practices do we want operating in the UK? Who do we want to prioritize? And so in fact, enforcement, all it does is create that level playing field so that those good businesses who are already following the rules rightly get the advantage over those who seek to undercut our rights and, you know, underperform on their obligations. So I think it comes to that big question. And I think what we need is now a kind of reckoning to kind of get business up to speed with what we really meant by the Data Protection Act, which wasn't just a bunch of risk assessments that sat in a corridor, but was actually looking at changing the way our data practices work in the digital economy.
Thank you. That was very eloquently put. Do Nick or Adam have any comments on this, or before we move on? No? Okay, thank you. Back to you, Alison.
Thank you. So I'm going to step back in and take the next question. Are there concerns about the commitments that the UK might be making in treaties such as joining CPTPP that you think will affect future policy space? So maybe if we could start with Nick for this one, please.
Great question. Could be a long answer, but I won't do that. Yeah, well, the answer is, of course, yes. And we can't really know the extent of what those impacts will be, because it's not really, I don't think it's really appreciated that CPTPP is not a negotiation to join just that text. It's a separate negotiation with every other party who will want side letters, and they will want to achieve some extra benefit for themselves as part of the negotiations. So we're going in as one new party asking to join, and all of them can ask for concessions. And any one of them can block us joining the entire thing. So it puts even very small economies in a uniquely powerful bargaining position vis-a-vis a much larger economy like ours, because they have a veto power. So we have to accept that we're going to be asked for things we probably don't want to give. And given the level of enthusiasm this government has for this project, my guess is we will end up making concessions that we will wish we had not made later down the line. That said, in this area, we would retain the regulatory autonomy to deal, for example, with onward transfers from those countries, because there are enough conditionalities in the existing agreement to allow that, unless we agreed in a side letter something different. So I think it's probably not that dangerous with respect to this area. than it might be with others in relation to basic tariff reductions and the impacts of those on domestic industries and the like, because in this area we already would have a good deal of regulatory autonomy. That said, the government would have to take that into account and be quite firm in taking advantage of that regulatory autonomy in order for us to gain the benefits from it.
Thank you. Could you, just to bring to life, you said there might be some kind of concessions. Have you got a couple of examples of the kind of thing you can imagine being agreed in future?
Well, it would be done by a side letter, or if you look at CPTPP now, you'll see that there's a very large set of annexes to this, which include the different conditions and flexibilities that each one of those members has negotiated. So any one of those members could ask for anything. They could ask for some kind of equivalence from us, for example, in data terms, and we could grant it. And if their data protection regime is not sufficiently robust, and a leak happens of EU nationals' data along with our own, for example, that would have a serious negative impact on us and our adequacy itself, or could do.
Great, thank you. Duncan, the same question to you.
Brilliant. I mean, just to, I think Nick's covered really well, like the big picture, and I think just to give a bit of flavour about some of the detail maybe that concerns some people within CPTPP. So, for instance, in the source code provision that they have there, which basically, as was previously explained by a number of panelists, basically stop states from being able to require access to source code as either a condition of market access or for selling products in here. The only derogation that's allowed within CPTPP is for patent law. So if there's a patent law issue, that would be a legitimate reason with which source code could be required to be revealed. Interestingly, they don't even have the pursuing a legitimate public policy objective that Emma Lee was talking us through before. And this just leaves a whole host of areas where we would legitimately think about needing to see the source code. For instance, if we saw another flash crash in the stock market, we would really want to see the algorithms doing some of that high frequency purchasing. We've seen now, as cars become more and more not kind of mechanical devices, but complex electronic devices, especially with these self-driving systems, if there are serious accidents, we would want to see inside them. And again, at the moment, the derogations within CPTPP would not allow for those. Similarly, on the data flow section, it has a clear obligation that each party shall allow the free flow of data by default, and that includes personal data. Now, again, here there's an opportunity to deviate where you're pursuing that legitimate public policy objective, but these could be really challenging in a kind of digital environment, because not only is legitimate widely seen as kind of widely recognized, and so novel policy responses to novel issues may not be defined as legitimate, which is kind of the first one. And then finally, also the necessity test, that we have to do the bare minimum in order to achieve the policy objectives, again, could mean that we're challenged in kind of deviating or restricting any kind of data flows. And again, just on that, pursuing a legitimate public policy objective, in 44 times that states have tried to apply that, they have only actually managed successfully, legitimately, to do it in one. So it is although it seems like a massive opportunity for states to diverge in their practice, in actuality, when you look at the case law and when you look at what's happened, it's very, very hard for them to use it just because of the detailed way that they've defined it. And then finally, just also on the data protection, and this speaks to a little bit what Nick was saying, is the data protection clause in the CPTPP encourages the mutual recognition of our data protection regimes, while also saying that voluntary regimes are absolutely fine in terms of meeting data protection. And this could create a pressure, especially under the complex negotiations that Nick rightly says will be undergone, not only at a group level with all the countries, but at an individual level, to kind of seek these concessions and to kind of seek some of these countries, as Nick rightly said, might seek an equivalence of their voluntary standards with our much, much more prescriptive binding standards. And again, so those are just kind of 3 examples of the challenges that CPTPP kind of would throw up in our policy environment.
Thank you. That's great. That really helps to bring it to life, especially that idea of, you have something in policy and then the reality of putting it into practice and testing it, and how many of those go through really brings it to life. Thank you. In the interest of time, I will move on to the next question, who I think it's going to be covered by Caroline Lucas MP.
Thanks very much, Chair. Yes, so I had a question which I know Nick has to go any second, so I might just quickly put it to him first before coming to Adam. But it's basically about the 4-year agreement that we now have with the EU, conditional on maintaining standards. But you'll know that last month there was a report from the government's task force on innovation, growth and regulatory reform, which recommended scrapping GDPR. I know we've touched on GDPR already this morning, but can you just say a little bit more that if we deviate from the EU-UK data agreement, what will be the cost for public services and businesses, both in terms of disruption and additional financial cost, and would it also presumably hurt the UK's reputation as well?
Excellent question. You need an economist for this, but even they would have a hard time quantifying this. I think that the short answer is because it would introduce so many uncertainties on so many levels. What industry does when there is uncertainty is stop. If you can't quantify risk, you don't take a risk. And even if you can quantify a risk, your lawyers may still ask you not to take the risk. But companies are very risk averse, especially if they can't quantify the risk. So in that instance, all sorts of sensitive data that is part of other commercial transactions would have to be, either that data for EU nationals would have to suddenly be moved to the EU and no longer enter the UK's jurisdiction, or you would have to stop using it if you were a company. But that's only the beginning, because so many, you can't easily separate all personal information from non-personal information. It's just not that straightforward. And some personal data is integral to almost everything, even if it's a very small amount. So the reality is a lot of things would stop happening because the operators would not be able to quantify what would happen to them if they continued for quite some time. And given how much of services is digitally enabled, and that we're the 2nd largest services economy, you can only imagine significant negative impacts from this. But it would be very hard to quantify them in advance of something like that happening, or the prospect of something like that happening. I know before the EU got Adequacy, a very large company turned to me for advice about this, because they were tired of talking to lawyers about what happens if there isn't Adequacy. And I said, look, if I were you, I would just move EU nationals' data to your Luxembourgish office, because at some point, do you really want to worry about this anymore, or do you just want to handle it and move on with your lives? And that is in fact what they did. So I think that's an example of what would happen, but on a much larger scale. And of course, we know that the data is the ability to use data and transform it in terms of innovation is critical. And so a barrier like this would have very large knock-on effects to all kinds of other things, research institutions and research uses in new and emerging technologies and algorithmic development and many other things. We would lose a big competitive advantage, I think, in most of the technologies of the future, which require data processing as an integral element of them. And I'm very sorry for injuring my foot, which requires me to go to the doctor early.
Good luck with that. And thank you so much for being with us. I hope you haven't been in too much pain. Adam, could I just come quickly to you on that question as well, just to see if you had anything to add to what Nick has said?
Absolutely. So on the numbers, Duncan went into some detail already, and 1.6 billion, I think, was the cost of losing Adequacy. So obviously, it's incredibly important that for companies and businesses to maintain that. And the Commission and all the other European institutions are keeping a close eye on what the UK does over the 4-year period. So this could jeopardize adequacy even before then. And as you mentioned, this report from the Task Force on Innovation and Growth and Regulatory Reform, there's also issues have been raised previously with the UK National Data Strategy, which just last year was stated that withholding data can negatively impact society, which was the EDPB warned that this would be risk of breaching the GDPR. You've already mentioned the new NHS digital data store for 61 million NHS users, which it's not sure whether this will be fully anonymized and can be used for commercial purposes. And this obviously contrasts to EU law on the issue. The Data Governance Act allows data to be transferred throughout the EU for economic purposes, but with important safeguards that the UK doesn't have. And also the Online Safety Bill is raising the issue of the duty of care, which could undermine intermediary liability. And on the EU side, we're currently negotiating the Digital Services Act, which will also hope to tackle all these problems of online harms like disinformation and illegal content, but specifically by focusing on illegal content and encouraging platforms to provide risk assessments rather than encouraging them to police the internet or moving responsibility onto the private sector. So yes, and if I can give you an example of the political repercussions, just last month, 30 EU citizens were detained in immigration detention, and this became a major political issue, which Commissioner Šefčovič raised to the Brexit minister. But now with the immigration exemption and the GDPR, we're facing many more, could be facing many more cases of this with, I think there's 400,000 applications still pending for the settlement scheme at last glance, and many thousands more EU citizens are likely to miss the deadline. So then they will be subject to this immigration exemption. And I'm sure that will then become a major political issue, threatening not just the adequacy decision, but perhaps even the trade and cooperation agreement itself.
Thank you very much. I'm very mindful of time, so I'm just going to move on to the next question, which I'll come back to you again on, Adam, if that's okay to start with, but then go to the others. We've mentioned the Schrems case already, and there have been challenges to data flows like the Schrems case in the EU, but there's also been an emphasis on data localization in countries like India. And I just wondered if you could just offer some reflections about how the UK should respond to those. I think you're on mute.
There you go. Yes, the European Parliament actually predicted the Schrems case because it also objected to the adequacy agreement in 2018 in its resolution. And the Schrems case indicated that obviously, US surveillance programs were still in place and largely unamended after the Snowden revelations, and that there was not sufficient judicial redress for EU citizens, and the UK could be facing the same issues with its own adequacy agreement because many of the issues are the same. And obviously this led to consequences with the US. This led to increased risk of fines under the GDPR and costs for businesses, and further impact on third countries like the UK that still operate surveillance programs. So obviously I think that the best response for the UK would be to recognize this risk and reassert the UK's commitment to the GDPR. And I think Emily Jones made some very good points about engaging with the civil society and the public space further in trade agreements to make sure that these do not undermine GDPR and threaten businesses via removal of the adequacy decision.
Thanks very much. Can I come to Duncan next, perhaps? And I don't know if you have anything to say specifically around the Indian approach with more data localization too.
Absolutely, yeah. I mean, just quickly on the Schrems one, it speaks to that, that we're still only just grappling with what the real implications were of the legislation that we passed. And Schrems isn't, the court didn't extend some principle, but just applied the law to those kind of data transfers. But ultimately, the result of that, which was potentially stopping data flows between the EU and the US, kind of seemed unpalatable. And so we have a kind of lack of action from the court judgment, and then the commission deciding not to really apply the ruling and the logic of the judgment when applying the UK adequacy. And I think that's hugely damaging for kind of data protection regulation, how it's perceived, but also, again, it allows those bad actors to take advantage versus those companies that take the extra effort to comply. And my work has really shown that there is a significant cost to complying, with all of this. I mean, I think the India, question is really, really different. And they're trying to carve out a kind of what I'm calling like a fourth big strategy. If you take China, the EU and the US as all having their own distinct kind of data policies, India is trying to carve out a kind of fourth way, where it sees it really wanting to, kind of build that digital sector. And whereas obviously a lot of the talk has been about data localization and how, they're using that as a frame to kind of how they can foster and build and nurture a kind of local industry, as has been the case in, many, many countries, and has been an accepted way of kind of developing policy, is to initially kind of protect it a bit. You've got examples from Norway and their oil industry to South Korea and their technology industry, where initially there's a bit of protectionism and you need to kind of foster that industry before you can obviously let it compete globally. And for me, India is just trying to, walk a bit down that road, not wanting to either take on the kind of the Chinese model or directly the EU model or the UK, but foster something locally. And I think that again speaks to the challenge of building these global agreements that are actually meaningful, when you've actually got four such big geopolitical players all seeking dominance. And there's also this feeling, I think, in the digital economy that it is a winner takes all, and that there's something, and you've seen it in the tactic of tech companies, but also obviously now in state players with their regulation, that they want theirs to be the global standard, theirs to be the single platform. And so there's a huge kind of geopolitical game in trying to get yours to bubble up the top, just as we see in a lot of the platform companies, where they're willing to lose billions and billions year after year after year, seeking that top spot. And I think that's definitely some of the challenges. But and also just on the data localization point, although I think generally it's not something that we need to prioritize, I think there are certain circumstances where it is really, really important, and we shouldn't discount it as a policy tool that we should be using here as well in the UK.
Thank you so much. That's really helpful. Jim, did you have any quick reflection?
I'll try to be quick. I think the one thing I would just remind everyone is the immigration exemption. Our organisation took that to court along with the 3 million. That's repeated all over the place. There are many, many of these exemptions in UK law. They haven't all been in front of a court. We also have the government at the moment proposing in the National Fraud Initiative to extend data sharing to police use for investigating crime, and also in the Police and Crime Bill for to share data for investigating potential violent crime. The legal framework in GDPR and UK Data Protection Act requires safeguards across all of these, and that's why the immigration exemption has been found unlawful by the Court of Appeal. But the government has no desire to put those safeguards in place, and because of that weakness, I think we're going to see the same problems emerge for adequacy across the piece in the way that the government is treating data. You add to that the National Data Strategy's desire for huge data sharing and the sort of things we've seen in the NHS or have been referred to. You have a recipe, I think, for complete disaster here. The government really does not care about privacy. It cares about data sharing and economic growth on the back of that, including personal data from the state being shared with the private sector. That's what it's after. I don't think that approach is compatible with the kind of data regime we should want, but also the way that it's meant to work with data adequacy in the EU.
Lovely. Thank you so much. Back to Chair.
Thank you. We are officially nearly out of time, but I'm going to politely request if the witnesses don't mind overrunning a bit. I'm sure that some of the commissioners might need to drop off at 12, but we've got one last really important question around SMEs that I want to get to, and then also as a kind of wrap up, it would be great to come back to the witnesses and just ask if they have kind of one big recommendation that they would make going forward for how we tackle some of the challenges that have come up. So if you do need to drop off, please do. I appreciate we've overrun, but if you can hang on a few more minutes, that would be fantastic. So I'll hand over to Jeff Mackey for the SME question, please.
Thank you very much, Chair. Never one to miss an opportunity to overrun with large questions. If I may just pick up a couple of things. Nick has obviously thrown a couple of rocks in the pond and stepped away when he said business would simply stop regarding compliance. And also, Duncan, you talked about the costs of compliance. The reality for business, and particularly the SMEs, is compliance with data and digital rules can be an absolutely major investment, never mind the headache that we have. Would you like to give us some clues what on earth we do about it? Duncan, can we idly start with you, if I may?
I'd definitely like to give it a go, yeah. So, you know, SMEs are so important for our economy. You know, especially when we're talking about digital and tech, our mind immediately goes to the big and the players and the names that we see. But, you know, our economy is built on SMEs, on small and medium businesses. They're the engine both in terms of GDP, but also in terms of employment. And so we you know, they absolutely need help. And data protection rules are one of those which apply disproportionately to SMEs because they set these quite high bars about what needs to be achieved. And it doesn't matter where you've got 5 people in a database or 5 billion people, you still have to do those checks. And what we've also seen is that, you know, so I work for a small charity, we had to do a huge amount of work covering our lists, you know, to make sure that we were GDPR compliant, when actually, in terms of the risk that we posed, you know, it was really, really minor. And yet proportionally, we probably spent more of our kind of annual spend on GDPR compliance than probably someone like Google, you know, which goes to show. So I think there are a few things to do. So there are important to consider whether there should be kind of exemptions at the lower end for some of this stuff, so that both startups and small and medium businesses don't have to comply with the full force of the law, or we give them a kind of lighter touch way of complying with the law. I think what we heard out when we, you know, as part of our research before, when we spoke to the Federation of Small Businesses and others, was that also there's just a lack of capacity within the SME community to even absorb what is, you know, this is my job, and even I struggle sometimes to fully absorb the consequences and the impacts of it. Well, when I'm struggling and I'm, you know, already working full 15-hour days, do I have another opportunity to either learn about it myself or to contract it out? Well, that's very, very difficult. So we heard resoundingly that the SME community needs much more support, either in managing the transition, in helping them understand the requirements, in putting up kind of standard templates, you know, to help them do these things. So they remain kind of so important. But it's also important to say that they also can be areas of, you know, really problematic breaches. So what we've seen also, obviously, with the way the data economy works is lots of small companies, you build a free app, you plonk it on the app, you just gather all the data, you sell on the data. That would be an SME, but that would be a hugely problematic data practice. So everything I've said comes with this big caveat that we also need to be careful, because actually they can actually be some of the, you know, worrying actors within the digital economy. So unfortunately, there's no easy answer.
I'd like to come back on this.
Really helpful, Duncan, as part of the film. Thank you very much. Jim, could you next and talk about the frame for the SMEs to work in?
So I think obviously this problem exists, but I would just ask people to consider, you know, were the compliance costs of GDPR high in Germany when that transition happened? And I suspect they were extraordinarily minimal, because the GDPR essentially reflects more or less the legal position in Germany as it was. I don't hear, you know, what I think happened in the UK is our data protection practices with Data Protection Act were so poor The enforcement was so lax for so long. We had a huge catch up to make. And of course, that is a burden. That change is a burden. But more change is more burden. So I think that's the first thing we have to think about here. The second thing is the risks that come from poor compliance are also a massive, massive problem, even in small and overstretched sectors. To take the charity sector, it was collecting people's emails willy-nilly without proper consent for years, and people were having trouble getting off lists and all that. It was just a nuisance value, but it was also engaging in profiling practices to identify high worth donors, which was simply unlawful. And it was doing this because it had an economic incentive to get donations, again, for years. And that just didn't stop until the threat of fines and GDPR came into place. That was reputational damage that was being done to charities by hassling people who were, for instance, had no money, were repeatedly guilt-tripping old age pensioners. I think there were even suicides that came from that. So one can't just assume that because businesses are essentially ethical because they're charities, or have some compliance issues, that harm doesn't result from not understanding the risks and not complying with the law. So I think the real challenge here is to support businesses in the transition that should be happening. My worry right now is because the government is saying, well, we're going to pull the rug under for everyone's feet and change all the rules, that actually companies are not going to seek to comply with the current law. They're going to stave that off, and we're going to have more uncertainty until new rules potentially come along, which again just require everyone to rewrite everything they're doing all over again, and then run parallel laws if they're rules if they're trading with Europe, because they've still got to comply with the GDPR set. So I think we're probably better off just sticking where we are, frankly.
I dare not start commenting, Jim, because actually I'll go off on one as well. It's a fabulous area. Adam, you have the last word. What do we do?
Wow, what an honor. So obviously, if I could, the extra point I'd add, apart from saying that, of course, the government should respect the court judgment on the immigration exemption and introduce necessary data protection standards into onward transfers to make sure that adequacy is maintained. I think the additional point is that the EU position is always shifting. So, I mentioned before things like the privacy regulation, which is going to, help to implement the rights we have through the GDPR, through having dealing with everything from cookie banners and making sure we have rights over our communications data as well. E-privacy, the Digital Services Act, which is dealing with targeted advertising, giving users control over the recommender systems and what information they receive. For companies trading with the EU, they're going to lose out on this opportunity of harmonization as well. And this is these are yet more indirect barriers to trade that the government should take into account.
Apologetically, back to you, Chair.
Thank you. I think the message that came out loud and clear from me, and certainly that I've seen in the industry in my own experience, is the uncertainty is what really puts a big burden and potential cost on the SMEs are much less set up to absorb. So thank you for drawing that out. So just really to wrap up very, very quickly, because we are already overrunning, if I could go to each of the witnesses just to ask for your what would be your one big recommendation that we can consider and potentially put into our report that we'll go through to the government. So Jim, maybe if we start with you.
Well, I think on the data flows, the government could be either negotiating side letters or just simply not signing these clauses with these necessity tests. That would be the big single call. And also, I think on the algorithms that similar commitments to roll those back ought to happen. To stretch it to a second, the previous panel was talking about a strategy for all of this. I think it's disgraceful that we haven't had a public debate about what all this means, and the government is operating a strategy. It's just not telling us what it is and what its actual aims are. It's doing that surreptitiously. That's, to my mind, undemocratic, and it serves us all extremely ill.
Thank you, very well put. Thank you. Duncan?
Yeah, I mean, I think probably my big ask around, definitely around the trade deals would be, just that in those sensitive issues areas where we've spoken and where Jim, where Jim raised it as well, that we do carve out that policy space for things beyond, kind of legal disputes, patent, copyright, which actually benefit the kind of the holders of these kind of rights. Then, as well from being from a civil society organization, just more ways in which we can reflect the knowledge that we have and the communities that we kind of represent into the wider strategy and the agreements. It's really important that we consider the needs of business in this, but as has been widely said, there are other considerations as well. My think tank is all about thinking about the flows of value beyond money. And I think that's a bit what we've been talking about here. What is some of the social return on investment of actually having good privacy law that maybe doesn't reflect in GDP and hard numbers flowing around, although I think it can do in that as well. There's no question, Apple is so profitable partly because of its privacy narrative. Whether that reflects its privacy reality is a one for another day. So those would really be my two. And then my if I can venture a third.
In the UK, but in all future trade agreements that.
Great, thank you so much. Okay, close. I just wanted to wrap up by saying a huge witnesses and really help to bring to life policy versus how businesses and citizens are dealing with the reality. So all of this evidence and your recommendation putting forward to the government and different done in this space to improve the situation for the UK. I really appreciate it. Thank you. Bye.
Thanks.